Legislative Commission to study the Energy Facilities Siting Act. At this hearing, we have some very distinguished guests. Representing National Grid is Peter Lacouture from Robinson and Cole. And here from the town of Burrillville is Special Counsel Michael McElroy and his partner Leah Donaldson to talk about the bill that they drafted and I submitted last year that would extensively revise the Siting Board Act. So with that, I think Michael and Leah, you have a presentation for us, which we're all very anxious to hear, and then we'll hear from Peter. And perhaps when Michael and Leah are done, if any of the commission members have questions of them, that would be an appropriate time to ask them, or during the process, just let me know if you have a question. So with that.
Thank you, Mr. Chairman, and I'm happy to take questions at any time. You don't have to hold them for me unless the chair feels otherwise. We're here to talk about the Energy Facility Siting Act as it exists now and some changes we think would be a good idea. The first thing I'd like to make absolutely clear is that the changes that we're proposing have nothing to do with any pending dockets at the Energy Facility Siting Board. It would be prospective only. It would not be any attempt to interfere with the process that is currently going on over there with regard to Invenergy, either the power plant or the interconnecting transmission lines or other dockets that are currently pending. It would only apply to new dockets that would be opened after the legislation is passed, if it in fact is passed. And so what we were charged with by the town council in Burrillville is we were asked to take a look at the act based on the experiences that we had had, based on information we were given about the experiences that the town had had during the Ocean State Power Energy Facility Siting process, and to make recommendations as to what we thought might be improvements. And the first thing that we did is, and Leah will go through this in detail, is she went through other similar energy facility siting acts in our neighboring states and elsewhere, and basically cherry-picked from those things that she thought, with consultation of me and ultimately with the members of the town council, would be well-suited for Rhode Island. One example, and I'll let Leah get into the details, but one example is we only have 3 members on our Energy Facility Siting Board. All of the other communities have many more, up to 9 members. These are complex, at times convoluted dockets with experts providing testimony on scientific matters and engineering matters, and it's a huge amount of material to be reviewed. I think it's a real burden on the 3 members of the Energy Facility Siting Board to work their way through all of this. And there's 2 reasons that make it a burden. Number one, the 3 members of the Energy Facility Siting Board, by statute as currently written, are number 1, the chair of the Public Utilities Commission, number 2, the director of DEM, and number 3, the director of the Office of Statewide Planning. All 3 of those people, as I'm sure you know, have very important, very busy, very time-consuming jobs. Yet in addition to their day job, they are now sitting on these Energy Facility Siting Board matters as well. It's a real challenge, I'm sure, for them to make time. The second thing that makes it difficult is that the Energy Facility Siting Board is subject to the Open Meetings Act. We are not, by the way, proposing that they should not be subject to the Open Meetings Act. We think the Open Meetings Act is good, and they should be. But it does make it more cumbersome for the board to review large amounts of materials and discuss it. And I think one of the reasons that the original drafters of the Act put the chair of the PUC, the director of DEM, and the director of statewide planning on the board is to have expertise in different areas so they could draw on that expertise in evaluating the overall application. Really good idea. The problem under the Open Meetings Act, however, is they cannot talk to each other unless they are in the same room in a duly noticed open meeting. So they can't share their expertise unless it's pursuant to a duly noticed open meeting. So an awful lot of stuff can be filed. Thousands of pages can be filed between open meetings. And generally speaking, what the board tends to do now is have motion days where it rules on pending motions, but it is not actually discussing the substance of the matter and is postponing that until after the evidentiary hearings take place. I think it would be helpful to just give an overview from the statute as to what the statute is intended to do. It applies to major energy facilities. They're defined in the statute. They're primarily things like power plants over a certain size and transmission lines over a certain size. And the purpose of the Energy Facility Siting Board is to make sure that the energy that's going to be produced or transmitted is done so at the least possible cost to the consumer, and that it's produced with the fewest possible adverse effects on the quality of the state's environment. So there is an obligation on the applicant to show that the facility is needed, that it's cost-effective, that it will not unduly adversely impact the environment, that it will be beneficial to the socioeconomic environment of the state, and that it meets the state's guide plans. Those are the 5 things that any applicant needs to demonstrate. They do that by initially having a preliminary hearing before the board. The board at that point in time will decide what the issues in this particular case are. After identifying the issues, the board will then make a ruling at the preliminary stage as to which either state agencies or local agencies should be asked for advisory opinions. They have the statutory authority to ask for those opinions, and various agencies, depending on the issues in a particular case, are asked to weigh in the advisory opinions. The advisory opinions are then issued. The parties are allowed to take discovery during the process by asking each other information requests. Often hundreds of them are exchanged, and eventually the matter goes to regular evidentiary hearings. Before those hearings, the parties are required to pre-file their testimony in written format. They file direct testimony, and they file rebuttal testimony, so that when you get to the evidentiary hearings, the primary purpose of the evidentiary hearings is to cross-examine the witnesses who have already filed pre-filed written testimony. At the end of the evidentiary hearings, the parties usually file closing briefs, and then the EFSB commences the difficult process of meeting to discuss the various issues, ruling on those issues. A decision is then rendered, and then if any party objects or has concerns about the decision, they can take it to the Supreme Court within 10 days of the issuance of the decision. That's the process that we deal with right now. And what I'd like to do is turn it over to my partner, Leah Donaldson. She did the research for this, and have her
I
make
think
her...
Mr. Rosselli would like to hop in with a question here first.
Yeah, thank you. Attorney McElroy, thank you so much for attending, and
You're welcome.
Ms. Donaldson and Mr. Lacouture, thank you for coming today. So in your opening remarks, you mentioned about advisory opinions. Under the current statute, are those advisory opinions mandatory? Are they dependent on the project? So if there's a certain authority to handle different projects at different megawatts or whatever, when do the advisory opinions come into play? And are they mandatory or just at the discretion of the board?
They're at the discretion of the board. So what the board does at the preliminary hearing is it takes evidence to determine what issues the board will need to be resolving in order to make its determination on the 5 issues I talked about. Is it needed? Is it cost effective? Would there be undue harm to the environment? Would it support the socioeconomic environment? And would it meet the state guide plan? So once they look at a particular proposed project, they look at its location, they look at its size, they look at its type, they will determine which state and local agencies they feel can give them the best possible advice to reach the decisions they need to make. And they will reach out to those agencies and they will ask them for advisory opinions. Now, it's interesting the way it's currently written. The advisory agencies are supposed to render their decision within the particular period of time set forth by the EFSB, but sometimes they don't, either because of political reasons, they've decided that they can't come to a consensus, or they were given inadequate information, and so they couldn't they felt they couldn't justify making a recommendation without information that was missing, or whatever it might be. Sometimes they don't. And if they don't render that opinion, then they forfeit the right to weigh in after the fact.
Yeah,
You have a-
I'm sorry.
No, follow-up question?
Yes, please. Thank you, Mr. Chairman. Yeah, but one follow-up question. So, under the current authority for the EFSB, who, and I'm going to say this just the way I'm thinking, who's paying for those advisory opinions?
The statute specifically provides that the expenses associated with the preparation of the advisory opinion are borne by the applicant. So now, if the advisory opinion, for example, is being rendered by the Department of Transportation, and it's being rendered by the employees of the Department of Transportation, well, then there are no expenses because they're state employees and they're on the state payroll. On the other hand, for example, if a town is asked to weigh in on a complicated engineering matter that might be relating to zoning in that particular town, and they have to hire an engineer to advise them, or they have to hire a lawyer to assist them with the hearing, the professional fees associated with that are passed through to the applicant.
So these are in addition to the regular advisory opinion. So if they ask for a Department of Health advisory opinion, and Department of Health, for whatever reason, doesn't have that expertise, or doesn't have the, whatever it is, the resources to render that opinion, for example, a air quality study or whatever, does the applicant then pay for, under the current statute, those additional advisory opinions or that additional information?
Well, they're not additional advisory opinions. The applicant would pay for example, if a hearing is being held by a particular state or local agency, and the state or local agency has to hire a court reporter to transcribe the hearing, the applicant pays. If they have to hire outside lawyers to advise them, the applicant pays. If they have to hire outside engineers, the applicant pays. But I do want to point out one thing. You mentioned as an example air permitting. Air permitting is outside of the jurisdiction of the EFSB, so that doesn't get involved at the EFSB level.
Mr. McElroy, what would happen with a police presence? I know certainly in Burrillville we've had a very large police. Who would pay for that?
Well, that's an interesting question. I think you could argue that the cost of the police presence only for the hearings related to the rendering of the advisory opinion. Okay, so if the zoning board renders an advisory opinion, the planning board, you could argue, I think, that the police presence, if it's over and above what their regular salaries would be, you could argue that it could be passed through. On the other hand, I could see the applicant arguing that, no, they're employees of that town, they get paid by the town, this isn't any different than any other matter that they usually handle. So that would be a gray area.
Any other questions for Michael before we pass it on to Leah? Yes, David.
Just curious, I know when sitting on the town council, everyone comes in front of the council and they petitions it. The question I have is, they bring in their expert witness, and obviously the expert witness is always in favor of the person who's making the application. Do they have the same right to bring in an expert witness other than just state agencies?
Not sure I completely understand the question.
Well, if there is a question on how they're doing the project or whatever, and they wanted to prove that their method or whatever they're doing is correct, they can hire an outside agency to support their position?
When you say they, who are you referring to?
The applicant.
Oh, absolutely. Well,
Okay, that's what I'm asking.
yeah, here's what happens in terms of experts. There's a lot of experts. The applicant will always have expert witness testimony to meet those 5 tests that I talked about, okay? Anybody opposing the application who wants to be taken seriously had better have their own experts to say, no, the applicant's experts are wrong and here's why, and I've got a PhD or I've got an engineering degree and I should be listened to.
Okay.
In addition to that, the Act has a very nice provision in it that has in fact been used a number of times by the board, where the board itself can hire an independent expert to advise the board and charge the applicant for the expense of that. And the board has used that independent expert a number of times.
Thank you very much. Thank you, Mr. Chairman.
Mr. Rosselli with another question.
Yes, and I'm sure you'll get to this, and if not, well, maybe this is the time to ask the question then. And I'm asking now an opinion more than a stated fact. So in some of the opening remarks, you said that under current authority, the EFSB, when it comes to advisory opinions, are dependent on the discretion of the EFSB. Would there be any benefit to having automatic advisory opinions? Those are opinions, particularly if they're environmental in nature, or economic in nature, or the project is of such a nature that you just have to have them before you move on. Is there any benefit to that?
Well, I mean, frankly, I don't think so. Personally, asking me what I think. I think the process in terms of designating advisory agencies to render decisions works well. And we haven't really made a proposed change in how the board determines that. The board has an evidentiary hearing called a preliminary hearing where they listen to the presentation. They ask the attorneys for the parties to tell them what they think the issues are that they'll need to determine in that case. They ask them for recommendations as to what advisory agencies they think the board should reach out to. And I think that works. In many of the cases, it's the same advisory agencies. You know, they're always going to ask for an advisory opinion from statewide planning. They're always going to ask for one from DEM. You know, you've got to meet the environmental test. You've got to meet the socioeconomic test. So they're always going to ask for that. But in certain cases, they're going to ask for additional things based on the projected issues that are going to be raised in a particular case. And because I think each case is different, I don't think there should be a mandatory list. But that's just me.
Can I clarify one point?
Yes, Leah.
With regard to, am I on? I'm on. It says,
Yeah, you're on.
I'm up. It's up. I'm good. There I am. Okay. The EFSB has discretion with regard to many advisory agencies, but there are certain agencies that they have to ask for, and I think that's what Mike was saying, but they are required by the legislation to, for example, ask for an opinion from the Public Utilities Commission every time. They have to ask for statewide planning every time. So I think, is it DEM? There's another one that they have to ask every time, and I'm not going to remember it. Maybe. And, you know, so there's certain organizations where they have to ask whether they think it's important or not, but for exactly what Mike is saying, those make sense to be asked every single time. We do, and I'll get into it a little bit, we do suggest a broader range and possibly encouraging or requiring the EFSB to request advisory opinions from a broader range of organizations, depending on, you know, and we focus mostly on, of course, the siting of a major energy facility, right? And we'll focus mostly on that today. But of course, that's not the only thing that the EFSB hears. They also are going to hear expansion of transmission lines, et cetera. So when I think that to require the EFSB to ask for these onerous agency opinions when it's a transmission line expansion might make no sense. So there is an expedited process for applications like that.
Okay, perhaps Amy Moses?
Hi, Mike. You mentioned in your opening remarks that there are times when an agency that the EFSB has requested file an advisory opinion is unable to render that opinion. Could be a variety of reasons. Hypothetically, it could be because they don't have the information they need to render that opinion. Under the current structure, what happens in that case when an agency feels like it cannot render an opinion because it lacks the necessary information?
Yeah, it defaults to the board. So there are actually times when an advisory agency will either just ignore the request from the EFSB and just send nothing in, or the advisory agency will be unable to get a quorum together, for example, or they won't have enough information they feel to evaluate the issues. In that case, the determination of the issue defaults to the EFSB. And the penalty imposed on the advisory agency is that it no longer has the right to weigh in on that issue because it didn't render its opinion.
Jason?
Hi, Mike. So in the case where those agencies lose their right to participate, that may or may not be of consequence to them, but do you feel that that hurts the process overall? Is the process not served by not having that information? And do you have recommendations on other things that we should build in to the process or the legislation to require that we have enough information to make an accurate decision?
Yeah, Leah's definitely got specific recommendations regarding that, and I think, yes, it does hurt the process.
Thank you.
Okay, maybe it's a good time to turn it over to Leah Donaldson.
Thank you very much. You will have the slides probably in front of you. If not, we have handouts in the front, and they will be hopefully on the screen, assuming I can work the computer. So how did we get here? And I'm going to be as brief as I possibly can. Again, thank you for letting us come and make this presentation today. It's important to remember that this act was originally passed 30-plus years ago, and it gave the EFSB the sole authority. It took authority away from the municipalities and away from other agencies to grant licensing for new energy facilities that are over a particular size. The town of Burrillville has experienced the power plant siting process 2 times in the past 30 years, as Mike mentioned, and it's the town's experience, I think, brings us to a point where we understand that there are many things, as you guys probably recognize, that could be changed in this act to improve the process for Rhode Island. Also, as Mike mentioned, and let me reemphasize that we don't expect any of these changes to affect any pending docket before the EFSB. Any changes would be prospective only. So when we were charged to come up with a revised piece of legislation for the town, we went through and did a very extensive multi-state review. On the board, you'll see a list of this region that I did, but I actually kind of went across the country and reviewed legislation and policies and how this process works for states across the country. There's also been several multi-state reviews done by other states, so those are very helpful, and I've listed on the last page of the slides, I've listed the links to a few of the really helpful ones. I'm happy to send that to anyone if that's useful. But those compare and contrast. For example, New Hampshire had one done by an independent consultant, and they compared and contrasted various states with how New Hampshire does it so that they could decide how to make changes going forward. So we really, and you'll have to pardon me because I did this review several months ago, so I might not remember exactly where we pulled some of these changes from, which state, but a lot of these changes were inspired by other states as well as the town's own experience within this process. So we think that there's 9 ways that the act can be improved, and the other piece of information you have with you there is an actual copy of our proposed revisions redlined with a front page that's just a 1-page summary of the proposals that we suggest. But overall, what we think can be improved is we can improve the participation of municipalities. We can ensure that host communities are not unfairly burdened financially by this process. We can increase opportunities for public participation. We can improve communication and notification procedures. We can increase the size of the board. We can increase the amount of expertise and advice the board receives because our state has a lot of expertise and the board could benefit from that. We could make sure that applications have all the information we need to thoroughly vet an application. We can require that impacts on our carbon emission reduction goals are required to be considered. And we can increase our ability to ensure compliance once a facility is approved. So a host community like Burrillville is uniquely affected by the siting process, and we should not be, a host community shouldn't be unfairly burdened financially. So if a town or a city can't afford to participate in this process, the town should not be excluded from the process. So it's important to, there are some, and we'll speak about this, but there are some provisions in the legislation now that protect that, but it's really not enough for a town to truly participate in this process without being completely burdened. Now, while a host community is uniquely affected, every municipality in our state is affected when we place a power plant in Rhode Island. So we think that right now the Act does not require the EFSB to consider the input from any municipality in the state. So just as an example, with the docket that's before the EFSB now, the Invenergy power plant, there were 32 Rhode Island municipalities that opposed the facility. And the EFSB has ruled that it will not consider any of those resolutions as evidence. They will not consider them at all. So all of those voices of Rhode Islanders have been silenced by that ruling from the EFSB. And they were within their right under the legislation as it is now to do that. Now, what can we do about that? So we can ensure that a host community, for example, has a voice on the EFSB. So we are in a later slide, we're going to talk about how we think we should increase the size of the EFSB. And there's a lot of ways we can do that, but one of the ways we think we should do that is by putting members from the host community on the board. Now, it would be, we're suggesting 2 members. That would be a minority voice on whatever size board we have, but it would give the town a voice to be heard at every single a board meeting. We also think that the EFSB could require a host community to prepare an advisory report of some sort that talks about the consistency of the proposed facility with local ordinances, because it's the town or the city that knows best what those local ordinances look like, and how the proposed facility conforms to that municipality's comprehensive plan. And that could go to the EFSB to add to the information they have to consider. We also think that it would be wonderful to add to the Act that all municipalities are invited to submit a resolution for or against a proposal and why. And then the EFSB would be required to consider those resolutions and specifically mention those resolutions in their order as to how those did or did not affect the EFSB's end result of what they decide to do.
Could I interrupt for just a second and add this? These are provisions that we're proposing that would allow the municipalities to provide additional input to the EFSB that the EFSB would be obligated to consider. We are not looking to change the structure of the statute, which is that the EFSB makes the final decision. We're not trying to take that away. We're just saying, look, the EFSB, based on our experience, has not been very receptive to local input. And we think they should be required to consider such things as resolutions from the host municipality as well as others. But we're not trying to say that the host community should have a veto power over the plan. We're definitely not saying that. I wanted to make that clear.
Thank you. Let's see. So the next point that we want to talk about is the financial burden to undergo this very complex process. So we think that it makes sense to require the applicant to, so right now the applicant has to pay if the town hires, as Mike talked about, if the town hires an expert, they have to pay for that expert up to a particular limit. If we want to do an environmental inspection, they have to pay for it up to a particular limit. We think that the cap should be raised. Right now it's I think it's 100,000 or 0.1%, whichever is less. We think it should be 150 and 0.1%, whichever is greater. So we think that because of just it's been 30 years and 100 grand doesn't go as far, we think that that needs to be increased.
And just those caps apply to the applicant, not to the town, correct?
The cap applies to how much the applicant has to repay the town.
Right, the applicant's on the hook for the first 100,000, then it shifts. Okay.
That's correct.
And you would raise that?
That's our suggestion.
Yes. Okay.
Let's see. We also think that there's a couple things that once a plant, and this comes from some of our neighboring states, once a plant is approved, there are certain things that we think an applicant should have to provide for the municipality. For example, a special inspector to aid with creating an emergency plan, to aid with making sure that construction is within compliance so that the town isn't burdened with having somebody to do all those things. Plus, these are very specialized projects. So to allow the town to hire someone who understands how to do that and to do it well, that burden should be, the payment for that should come from the applicant. Also, we think the applicant should be required to provide funds for local training of our safety personnel, as well as safety personnel, emergency personnel from neighboring towns who would aid us if there was a large emergency at this power plant. So if something happens at the facility, it's not just going to be the, Burrillville, it's going to be neighboring facility, and we need to know how to deal with an emergency like that. And we think that the applicant should pay for that training. The next point has to do with communication. So the Act does require, quote, public input shall be part of the decision-making process. But then the Act limits the ability for public input. It also limits the number of residents who get direct notification. It only requires notification to, quote, abutting landowners. We think that that could be broadened. We think that, first of all, the applicant should be required to notify a host community before the application is submitted. When a host community is notified after it's been submitted, all of the residents are calling. We don't know what to say. We think it's fair for the host community to be aware of what's going on before it's filed. The applicant knows well in advance that this thing is going to be filed, and this would allow us to open communication, to have a good neighborly relationship with the applicant. We also think that we should increase the number of public hearings. We're suggesting 3 in the host community instead of 1. We think that, that public notice requirements should be a little more specific. So some of our neighboring states require, and this is where I've taken this from, a half-page newspaper ad that includes a map of the project so that residents understand whether this is going to affect them or not. Here's where the project is, this is where it falls, and that way they can understand whether or not they want to show up for the public comment. We also think we should broaden notification requirements for adjacent landowners. This was, again, taken from a neighboring state, I can't remember which one, to, instead of just abutting, to be a radius. We're suggesting 3 miles from the project site. And then for things that aren't electric generating, 1 mile from the corridor. I think I saw.
Yes, Mr. Rosselli.
Thank you, Mr. Chairman, and thank you for the presentation so far. On the number of public hearings, I just want to make sure I understand what it is we're trying to do, and also what the current authority is of the EFSB when it comes to public hearings. And for many of us here, the public hearings have always been one way. So it's been a one-way discourse. Somebody gets up, talks. There's never been any two-way communications. No questions are asked. There's never any rebuttal to any of the information that's presented. Unlike some of the other things that happen in local municipalities, planning boards, zoning boards, there's always a two-way. You can ask the planning board director, zoning board director questions and get an answer. Not in the case here. In my mind, having more public hearings really doesn't do anything for the process. It's just another way for people to either give factual information or vent.
Mm-hmm.
If there's a way to actually have individuals ask questions and get an answer, that to me is a more participatory type of discussion. Have you seen any other EFSBs or siting councils all across the country where there's actually where the authority lies in the EFSB to actually give them the authority to answer a question?
Well, I love that idea. I have not seen that specifically cited anywhere. I'm a big proponent of providing information so that people have a better understanding. I think that's a wonderful idea, but if you're asking if I saw it in my review, I have not seen anything that specifically speaks to that issue.
I mean, there is that educational moment.
Mm-hmm.
There's the moment where someone is wanting to know, and we've seen this over the past few days, about a particular thing, and there's no way to ask that question and get an answer.
Well, right now, I mean, we're looking at this as objectively as we can, and it's a difficult job for the members of the board. It's difficult for the applicant. It's difficult for the interveners. It's difficult for the municipalities. It's a difficult process. If you ask a question at a public hearing, you really can't expect the board to give you any answers because the board is an adjudicatory body. Okay, that's not their job. What you can do is you can ask the board to present that question to the applicant, because the board, under their rules, can present what's called data requests, just like any other party can. So an intervenor can present data requests directly to the applicant. The board can present data requests directly to the applicant. Then the applicant, of course, is given an opportunity to consult with their experts and give a written response. So it's perfectly appropriate under the Act as currently written and under the board's current rules for a public commenter to say, Madam Chair, we have a question, and we would appreciate it if you would pose that question to the applicant. And of course, it's up to the chair as to whether they're going to choose to do so or not.
Ms. Moses?
In terms of public participation, for those individuals in the community that have been allowed to intervene, my understanding is, in the current system, they still do not have access to the confidential information. So by them technically being intervening and participating, they're not really a full party at the table because they are not allowed to see information that others who have signed non-disclosure agreements can see. I'm curious if this conundrum is present in other states and how you think we could remedy that situation here.
Well, first, let me address the issue of the way the non-disclosure agreement works. All of the confidential information is made available to the Energy Facility Siting Board, its attorneys, and its consultants. So confidential information is before them. When they render their decision, they've seen it, they have it. It's also made available to all of the attorneys and the experts for the parties who sign the non-disclosure agreement. So the experts can review the information in preparing their testimony. The lawyers can review the information in preparing cross-examination. And they can use the confidential information in writing their briefs. The problem is you cannot give it to your client, so that I can't disclose any of the confidential information that I've been given to anybody, to President Pacheco for the town of Barville, to Manager Wood. They cannot see it. If you're an individual intervening, your lawyer could sign the confidentiality agreement and would get the confidential information, but your lawyer would not be able to share it with you. And that's the compromise that's been reached. So that's how it works.
And that particular compromise was, that,
Up.
button up. Button up. Oh, I'm never going to remember. Button up. I know, and there's even a sign, but I'm busy making eye contact with Ms. Moses. So that particular agreement with regard to we aren't allowed to give it to our clients was made in this docket. Right, Mike? I mean, that's not necessarily true in every docket.
It
But I
was
don't-
specifically made among the parties in this docket, but frankly, it's common practice in
Yeah.
Public Utilities Commission matters where there is often confidential information. That's how it's handled.
And I will just add, because there's a lot of non-lawyers on the committee, and certainly a lot of non-lawyers at home watching this, that practice is not unheard of in other litigations completely, and, you know, we see that in the legal world, those types of agreements
Mr. Chairman, you're
elsewhere.
correct.
So that's not, someone at home might be listening to that and saying, how can you have an agreement that the lawyers can see it, but the clients, that does happen in the legal world elsewhere too. So I just, for the people listening at home. Mr. Sabatoni.
Thank you, Mr. Chairman. The act of the EFSB giving sole authority to deny or permit with the enabling legislation, why was that so?
Well, because I believe the intent of the act was to prevent local communities from vetoing a plant in their community or any other major energy facility in their community. And you wanted a centralized board to be taking into account the needs of the entire state as a whole, and then that would always control. So they get to decide regardless of whether a local community felt that it wasn't appropriate.
So in light of that answer, is it the town's position making these recommendations to this commission that would be beneficial to Rhode Island's citing process coming from a position of pro or con?
I don't understand the question. As I said at the beginning.
The town's recommendation and opinion that this would enhance the process, is that coming from a neutral position? Is it coming from an opposition, or is it coming from a positive?
Well, first of all, it's got nothing to do with any pending dockets. Our position
Going
is.
forward, I understand that, going forward.
So we don't have a pro or a con, we just want to make it better, based on our experiences. And absolutely, one of the things I said at the beginning is we retain the principle that the decision is the board's decision. A statewide board needs to determine statewide needs and render a statewide decision. We're not trying to take any local veto power and insert it into the act.
So the town's revisions and experiences would demonstrate that this would make this process more beneficial, how?
To the state as a whole. and so-
Specifically how?
So that for example, in the ways that we have recommended here, but I'll give you some examples. Information, so that there is more information available, that the information is furnished in a timely fashion, that experts can be hired to evaluate that information, and we think it would make for a more informed process overall.
Thank you, Mr. Chairman.
Okay, Representative Price, did you have a question?
Yes,
I think
thank
the
you,
Vice
Chairman.
has-
That's about the public input and confidentiality of information that's available. In order for the public to make to have some legitimate input, would it be more beneficial if they were afforded the opportunity to see more of the details of what's proposed in their area? Because I know that they're looking for water in other states, other towns. And I went to the Charlestown meeting at the elementary school, and there was an auditorium full of people that didn't know any of the details, so it was more of an emotional input than anything. So when you say that they meet 5 of the categories to the 5 categories that you're talking about, are those public is that public information?
Well, the 5 categories are required by statute. The applicant has to demonstrate that there's a need for the facility, that it's cost-effective, that it will not harm the environment, that it will benefit the socioeconomic situation in Rhode Island, and that it meets the state guide plan. All 5 of those must be demonstrated. In terms of information, there are thousands, I'm sure it's tens of thousands of pages of information already on file. And the EFSB has been great in terms of making that available. You can go for every filed major energy facility into the EFSB's website and click on it, and every document that's been filed is indexed, and you can click on it and you can see it. The only things you can't see are the redacted portions pursuant to the confidentiality agreement. And in order for that to happen, the applicant, if they want to protect something, and it's usually only a part of something. I do understand that they protected the entire water plan, but usually it's just a part of something. And what they have to do is they have to file a motion with the EFSB, and they have to explain why they believe that this is confidential and proprietary information, and that it would be damaging if it was released. And they have to make that showing affirmatively to the board, and if the board feels that they're right about that this could present a problem for them, then it grants the confidentiality motion. So it's not like they can just say, oh, I'm not giving anybody this. It's not like there's no oversight to that. The board has to review it and approve it before they'll allow something to be redacted. But almost everything is in fact available on that website. I would say 99% of the information filed to date is in fact on the website. Of course, it's always that 1% that people want to see.
Right. Thank you.
Vice Chairman?
Or at least the 1% they think on it, they want to see because they can't see it. So I had a few questions, but I might hold back on some because I know you guys still have more of a presentation, but just because I feel like we're kind of in this on the question about adding town members or members from a town to this. I see the town members as coming in with a much more inherent conflict, and I think adding them in, it strikes me at least as being something that if these these folks are supposed to be acting as sort of I have plenty of issues with the EFSB makeup at the moment. I think there's a lot of issues, and one of them actually is that there's a lot less accountability, and I don't think for folks across the state there's much accountability with the 2 town members. So I have a real anxiety about it, and I wanted to give you guys a chance to sort of help educate me if I'm off based on it, because I see a town as potentially being in favor or opposed very easily, and potentially being able to really, as they should, be able to shape a proposal from a potential, and potentially shape it in such a way that's very damaging to a neighboring town, which would have no representation, for instance, along the way. Take water, for example. There's a lot of water discussions around the current docket. Potentially, let's say that there was a body of water that the town didn't use, but sort of just passed through its corner, but was heavily used by a town next to them. They potentially could set something up where I just see a lot of possibilities for problems by enshrining that. The other question I guess I had was, I couldn't find in your paperwork, but I couldn't find a definition of what an energy facility is in that redlined legislation there. It may be somewhere else that's not listed, but it to me that dramatically changed when and where those things would come up, because it could be a much smaller piece. So
Rep,
let
it's
me
in
read those for you.
RIGL 42-98-3, parens little d, parens. It defines major energy
On page
facility.
3 of our proposed amended changes.
Generally speaking, if it's an electric facility and if it's 40 or more megawatts, it applies. If it's a transmission line of 69 kV or more, it'll apply. But there are more specific rules in there as well.
On my earlier concern, did you guys have anything you wanted to add in that?
Well, let me forward one slide, and we'll talk about the makeup of our current EFSB, and we'll talk about that in here. So I'm on slide 10, if you guys are following along at home. So we currently have 3 members, and like I said, our suggestion was to add 2 members of the town to address your concern. The board is, as Mike mentioned, subject to the Open Meetings Act, so any member from the town would be subject to the Open Meeting Act as well, so everything would happen in the open meeting forum. But also, based on my research, we had originally crafted the suggestion as sort of independent members chosen by the town. So it would be someone with specific, and I can point someone to some of this language offline, but with someone with specific energy or with this, within a range of required experience or expertise, but appointed by the town, so that the town had a voice also. So, it could be an independent consultant who served, as selected by the town also, as opposed to just anybody from the town.
What, Leah, would that person then therefore not need to be a resident of the town?
I'm not sure that we've asked that it be a resident of the
I see.
town. I'm pretty sure that we chose not a resident of the town. We said someone's appointed by the council.
I think you'd have a difficult time finding 2 brave souls from Burrillville that were willing to.
Well,
But then you have a situation, if we were to do it that way, where we'll use Burrillville, the town of Burrillville appoints 2 people, neither of whom are residents of the town. Now you may be facing a very angry public saying, why does Jane Doe from Gloucester get to decide what's going to happen in Burrillville or Hartford? And while we're on this point, I just want to point out in 2016, I introduced legislation that, among other things, would have expanded the board. And how I dealt with this issue of putting, having some local representation on the board was I asked that the board would have included a member appointed by the Rhode Island League of Cities and Towns. And maybe Mr. Daniels will have, he was not associated with the Rhode Island League of Cities and Towns at that point in time. But what happened is the league came to me and said, Representative, we don't want a seat on the siting board because we don't want to have to put one of our members in that situation where they have to decide the fate of another city or town, and we think that would be a terrible position for us to be in. And thank you for the thought, but we don't want to be on the expanded board. And so in the sub-A that ultimately passed the House, and then eventually the town opposed it and it was killed in the Senate, that that position was taken out, so it did not include a representative from the Rhode Island League of Cities and Towns. So I think Representative Handy has some concerns with actually putting someone on the board. I think it's a great idea, I just don't know how to quite accomplish it because of some of these issues, so.
It's very interesting how different states seem to deal with adding additional, there's some states that so many seats are appointed by the president of the speaker pro tem, and some are appointed by the president, and some are appointed by the governor, whereas others are.
I don't know if that would, that might,
I'm not suggesting that.
yeah, that might raise a separation of powers
Yes,
issue
thank
here
you.
in
No,
Rhode
I'm not
Island, but-
suggesting that, but there's a lot of different ways that different states are handling this issue, and what I like about the 3 states that we've used as examples here is that most of them are selected based on their given position somewhere else in the state. So they already have expertise at DEM, and therefore they're going to be immediately added to the board. So that just happens to be, we selected Connecticut, the nearby states that were good examples.
Okay, and I know we have some more presentation to go through, but Mr. Okowski has been waiting very patiently here to ask a question.
Thank you,
Jason?
Mr. Chairman. 2 related questions at this point. So a little earlier, we were talking about the public being able to ask questions of the applicant through the board, and that the board could require the applicant to answer those questions. I think, if I'm not wrong, the board has no obligation to do that today, right? So
That's correct.
The public can't compel the board or require the board to do that, correct?
That's correct.
Okay. So on the topic of the public participation then, in your analysis, have you seen other states that assembled maybe like a public council that was individuals of expertise that were pulled together to weigh in and as a way to expand the public input into this process?
I've not seen that, but again, the more public input, the better in our view, but I have not seen that specifically listed in any legislation. That's not to say that it's not being done in other states, but in the legislation I reviewed, I did not see that.
Yeah, I'd like to see some information on that, because I think that may exist, or at least exist in some recommendations out there.
Mr. Rosselli?
So any type of public comment, whether it be at the, probably less so at a hearing, but more so at if you become an intervener, requires a great amount of financial burden. There could be, and I'm basing this on my own little bit of research of what other states have done, and maybe to help Mr. Olkowski with his concern, that perhaps there's a public intervener. The idea of a public intervener is an attorney, because that's what the FSB requires, and that intervener, that public intervener, would act on behalf of the public. So in the case of data requests or questions to the board, or when you get to hearings, there's actually somebody there who represents the public, who is, as representative of some of the other concerns that are mandatory within the EFSB authority. But in this case, you have an attorney there required by the EFSB. You have to be an attorney to represent whatever. And in this case, it would represent the public. And there are cases like that throughout the United States.
And I've seen that in a number of places where there's a public advocate. We have essentially that through the Attorney General's office.
But not on site.
No, it's not
of
in the
FSB.
statute. It's not in the statute
it's
right
not
now, but it
required.
could be incorporated into the statute if it mandated that the Attorney General act as the public advocate in all of these cases. It does not. In my experience, the Attorney General usually does not weigh in on these cases, but I certainly think that it would be helpful if the Attorney General did so. You also have the Division of Public Utilities and Carriers that in a rate case, for example, weighs in on behalf of the public. But in this case, because the Public Utilities Commission is always required to render an advisory opinion as to need and cost, and because the Division of Public Utilities and Carriers acts as the advisor to the Public Utilities Commission, I think it would be difficult to require them to be a mandatory party acting on behalf of the public. But it would be an interesting idea to put a provision that says the Attorney General has to do so.
My only I mean, I like that idea too, and given the staff at the Attorney General's office, you might be able to do it, and you might be able to convince someone to actually take this on, and you might convince, under a particularly political leadership, to have the Attorney General do something like that.
Well,
But I'm
and the-
talking about a straight advocate, a straight public person who is hired by whoever, whether it be the applicant or a combination or the state, to act on behalf of the host city or the host town and for the public.
Amy?
In New Hampshire, my understanding is there is a role like this, and it's called counsel for the public, and it is an attorney who represents the public. Sometimes it's more than one attorney, but I certainly think that's something that this body should look at, creating an analogous role here in Rhode Island.
Sure.
Todd, you had a question? Okay, very good. Back to you, Leah.
Thank you. So I'm on slide 11. So we've talked a little bit about the issues on the next few slides, so I might breeze through them. So right now, the Act allows an applicant to submit an incomplete application. Well, it doesn't allow them to submit an incomplete application. They submit an application. If it's deemed incomplete, it is rejected. Then they may resubmit essentially the same application, just as incomplete, and it must be accepted by the board for docketing. Then they have until the evidentiary hearing to get their ducks in a row, and, you know, by the evidentiary hearing, they've got to theoretically present all their information to the EFSB, because that is the moment, right, the final evidentiary hearing. We think that's inadequate, because any advisory agency or, you know, the public need to be able to see the information before the evidentiary hearing, because all of this advisory, you know, all the experts are reviewing, all the reports are being written before the evidentiary hearing. And so the stakeholders really need this information up front. So our suggestion, well, I'll get into that in a second. So the other thing that the Act does is it limits the agencies that the EFSB must seek advisory opinions from, as we spoke about earlier, the PUC, DM, you know, so there's certain ones that they must, and, you know, there's other agencies that the EFSB could benefit from getting information from. It also doesn't require the EFSB to consider cumulative effects of related applications. So right now, as an example, the Invenergy application has an application before the EFSB, and then there's also the transmission line that works with that project. Those will be considered completely separately. The impacts, environmental impacts, et cetera, will not be considered together on those two applications. Now, it also doesn't require that the proposed facility, that we consider the impact on our state carbon emission reduction goals. And they can, but they are not required to. So we think that the EFSB, when they reject an application, the application should have to be corrected and completed before it is docketed. We think that those deficiencies, the burden is on the applicant to provide the EFSB with this information. They need to have their ducks in a row before they provide their application so that everyone can do what needs to be done. And I think we use the term substantially complete, because we all know that there's going to be something, you know, that can't be finished. So I think we've used the term substantially complete. But nonetheless, we need to have most of this information before us so that we can make these evaluations. We think that there needs to be a requirement that all utilities are in place, that the applicant's access to water, to power, to gas, to sewer is in place when they make their initial application. We think that,
Mr. Bianco.
go ahead.
I had a question about something you said earlier, sorry. Regarding the carbon goals of the state, you mentioned that the Act should require that. I'm sorry.
What I said is that the Act does not require it.
But
the Act does not require the EFSB to consider it.
is the EFSB not one of the state agencies required to consider the state's goals per the Resilient RI Act? Or is it already something the EFSB must require?
Well, I think that right now the Act does not require it.
But the Resilient Rhode Island Act that was authored by the vice chair and co-sponsored by myself is a later act of the General Assembly. So wouldn't the citing, I think, well, I'll let Todd make his own points, but the question is, isn't the fact that the General Assembly has passed this law, and signed into law, and the citing board is a state agency, aren't they required to consider what's in the Resilient Rhode Island Act?
Yeah, absolutely. I think that, yes, absolutely.
But this would make that explicit, that they must do so, which is a good idea.
Let's see.
Any other questions?
Okay, the other issues that we think that, I'm not, the EFSB rules and procedures, that's where the actual designation of what needs to be in an application is found. So an applicant, they want to know, what do I need to include? It's all listed in the rules and procedures for the EFSB. We think that there should be a regular review of that by the EFSB to make sure that it stays current. So as times change, we may decide that we want the applicant to include, how is this going to impact your carbon emissions goals? Therefore, we want to make sure that that is included in the application from the beginning. So having the EFSB do a regular review of those rules makes sense. And then, let's see.
Jump to the summary.
Okay.
Go right to the summary of the changes.
Oh, you want to go there? Okay.
Go right here.
All right, hang on. All right. Let me jump. I'm gonna jump to page 15, and then I will jump to the one-pager.
However
Yes,
however
please.
you'd like to do it, we're sort of peppering you with questions as
No,
as
it's
we go
fine.
along here. And actually, as I say that,
I'm-
Mr. Bianco has another question.
Oh,
Regarding the advisory opinions that the suggestion for the zoning, planning, building departments, would that be in situations where there is no license, or are you talking about a different type of advisory opinion beyond the licenses that are required by the Act to be sought for advisory opinion?
the first one. So the idea being that if they would have, absent the act, had to go through those agencies or those entities, that those should be requested for advisory opinions. So right now, and some of them are optional now, but if I remember correctly, it has to do with the, oh gosh, I don't remember which entities we wanted to add, but it was different town entities that we thought would be beneficial to the EFSB to hear from those town entities about how it would affect the town, financial and otherwise.
Well, for example, what has happened in the past is that the town, for example, has made a suggestion that the EFSB should consider certain things. It should request an advisory opinion from an agency within the town, or another agency within the state, or an agency within another affected town. And the board has at times ruled, yes, that's a good idea, and made that request. And at other times they said, no, we don't really think we need that information. We're saying that we think the more information the board has, the better, and that the board should be under an obligation, if there's a good faith showing that there's a link between what the information that could be provided by that state or local agency would be helpful to the board, that it should be required to be provided. Because when you just knock it out right out of the box at the preliminary hearing, you're never going to get that evidence. You're never going to go there. And we think that the more information the board has to make an informed decision, the better.
Yes, Terry.
Hi, good afternoon. I was going to ask a question on slide 13, but since you're about ready to skip slide
No,
13,
well,
I figured
please.
I'd ask it anyway.
Please.
In your analysis of other state programs, other similar structures, did you happen to note whether or not other states require a structured environmental impact analysis and alternative analysis similar to an EIS under the National Environmental Policy Act?
It's an excellent question. I would have to go back and check, because I just recently did a different survey on the same issue. And so I don't remember if my research was related to the EFSB acts or if it was related to something else. I know that I have seen it, but I don't remember specifically if it had to do with the EFSB.
I can also say that the EFSB in other dockets has ordered the preparation of an environmental impact document. Sometimes when the federal agency that's involved in permitting. It might be the Army Corps of Engineers, it might be the Federal Energy Regulatory Commission. If they determine, after they do their brief environmental assessment, that an environmental impact statement is required, then that statement will be prepared under the aegis of the federal agency and then submitted to the board. So that happened in Ocean State Power. There was, it was prepared under the authority of FERC and then submitted to the board. But even in places where the federal jurisdiction did not require the preparation of a federal environmental impact statement, the EFSB has in the past ordered what they call the preparation of environmental impact document, which is the functional equivalent of an environmental impact statement. And the board believes, and I agree, that under the Act, the way it's currently written, they have the authority to do that if they feel it's appropriate in a particular case.
Todd, did you have something you want to add?
I had about the advisory opinions again. It was just related to the mandatory ones. So would the town, in this case, there would be these mandatory advisory opinions, and the town actually, in that case, would have to do them even if they didn't want to? Or, and then have you thought that through? And if the town says, you know, this is additional cost, we actually, with this type of project, the town is on board and we don't want to provide additional advisory opinions, or does it get waived to the citing board for the citing board to decide as an advisory opinion would now if it's not completed? Because it does take a lot of resources to render mandatory advisory opinions at the town level. Even if someone else is going to foot the bill, it's still, that doesn't bring you new employees. That just.
Did we, frankly, Mr. Bianco, I don't recall whether we changed the provisions of the statute for which the only penalty for failure to render the opinion was that you lose your right to give input. I don't remember if we changed that.
We did not.
Okay, so we didn't do that, and they could just say, we're not going to do it if they chose to do so. One thing I would like to point out is that in almost every one of these projects since in the 30 years that the EFSB has been in existence, the local community has, by and large, supported these projects. That may not be the case in some of the currently pending ones, but certainly in the previous ones, they have in fact supported it. So you've usually got an alignment of interests in most cases.
Mr. Rosselli.
If I could, I want to bring you back and to the EIS, and Mr. Chairman, if it's okay with you, I'd like Mr. Gray to maybe make a distinction between what an EIS entails and what Mr. McElroy said was an impact environmental statement, because one is much more robust than the other.
Do you feel comfortable answering that, Mr. Gray?
I can answer in a general way, and the reason for my question is one, as you noted, has a very specific federal structure to it. You know, there's rules, there's an outline, there's a format that needs to be complied with. And I was just asking if other states had established that type of consistent legal framework for how that environmental impact analysis and alternatives analysis would be looked at in the context of an application.
Other states?
Well, that was the question I answered earlier, which was that I don't know specifically, but I have seen it in other states, but I can't remember if it was in the context of an EFSB.
Right. To get to Mr. Roselli's question, I'm not sure exactly what the difference is between the scope of all the environmental impact documents, I guess, that have been requested over time, and what's required under FERC for, or not FERC, NEPA for an EIS.
Yes, and my experience has been that when the Energy Facilities Siting Board orders the preparation of what they call an environmental impact document, or an EID, they usually combine that with the hiring by the board of an environmental expert to supervise the preparation of the EID, so that it becomes the functional equivalent of an EIS, but without all of the federal specific provisions.
Mr. Okowski.
Thank you, Mr. Chair. Just very quickly, so is it your position that the act should require an EIS or an EID?
Well, I mean, that's an opinion. My personal feeling, and it's just Mike McElroy's feeling, is that the board has shown the ability to be able to judge each project on its own merits and determine which of those projects need an EID, which of those will be getting an EIS from the federal government, and which of those don't have the kind of environmental impact problems that would require the time and the expense, because an EID can be time-consuming as well as expensive. And one of the goals of the Energy Facilities Siting Act is, to the extent possible, to expedite the process where it's appropriate to do so. So my personal feeling is that I think the board has done a good job deciding when that's necessary, and I would leave it that way rather than mandate it in every case.
Do you feel it would be beneficial to put some triggers in place? Amount of acreage is impact, wetlands impacted, any sort of things that would kind of trigger that versus all or nothing?
That could be done. We could sit down and that's the kind of thing that working with an expert consultant would be helpful, to get an idea from somebody who prepares environmental impact statements and other similar environmental impact documents, to get a handle on whether this particular, usually they're environmental engineers, and whether or not they feel that there are some triggers that we could use, but I don't have that kind of knowledge.
Yeah, I mean, it would seem beneficial, so I'd like to learn some more.
Leah, maybe you could continue with your presentation.
Sure.
Thank you.
So I'm back, I'm still on slide 13. I rolled back. So just because I want to mention that we talked about how the applicant may or may not have submitted all the required information, and then they get to resubmit it and it'll be accepted. And then the information goes to the advisory agencies. We also have suggested that if the advisory agency doesn't get the information they need, that there be some sort of automatic ability for the docket to be suspended, so that, because the time is running on that agency to provide their advisory opinion. And if they don't provide their opinion, they waive their right to weigh in, but they don't have enough information. And right now the EFSB there's another thing we've actually asked in there, which is to make it more clear that the EFSB can suspend deadlines, et cetera, things like that. But this would provide for suspension of up to 60 days if the agency is not getting what they need to do their advisory opinion. Let's see. Let me roll. On 14, we talk about operational compliance, and right now, the Act doesn't guarantee a lot of things with regard to compliance. So on 15, this is what we suggest with regard to making sure that once a facility is permitted, that it stays in compliance. So we're suggesting an increase in the fine per violation to account for inflation. We're asking that the board be required to take reasonable steps to ensure that it's in compliance. Right now, the board right now the board's not required to take to do anything really. We think that the board should be permitted to suspend or revoke a license if they find out that there was materially false statements made in the application. And we think that, to go back to the idea of, can the public provide enforcement? We think that the AG should be specifically authorized, as well as the host community, specifically authorized to bring civil proceedings to enforce compliance. And also, we think that the town should be able to enforce municipal ordinances, assuming those ordinances are not in conflict with the license. And that is a gray area right now. Clearly, if it was specific in the Act, then the town could levy fines if somebody is out of compliance with a particular municipal ordinance.
I'm sorry, you're saying it's a gray area whether or not the town can enforce their ordinances as long as they're not, I mean, I understand, in other words, if it's a conflict with the agreement or with the license, then I guess the license must hold state's preemptive
The EFSB, yes.
authority, but Are they not allowed to enforce municipal ordinances otherwise either?
Well,
It's a question of preemption, as
Yeah.
I think you mentioned. And the legal issue of when something is preempted is a very difficult issue to analyze. Was something intended to occupy the whole field when it, in fact, imposed that particular condition or of the license? Or was it saying, okay, this is a very specific condition, you must meet this condition, but the town can go ahead and use all of their other ordinances, enforcement powers for anything other than this? So that's the issue that you get into. We wanted to clear that up and say, of course, the conditions set forth in the license take precedence, but with the exception of those specific conditions, the remaining ordinances of the town remain in effect and enforceable by the town.
Leah?
Thank you. So the last page is just a list of the resources that I mentioned earlier. And we also gave you a package that has, as I mentioned earlier, a one-page cover sheet. And the one-page cover sheet covers all the material that we just went over, but it talks about it through each statute. So you can see where we propose inserting each change into the legislation. And then our red line copy is behind that one-page summary.
Thank you both so much for an excellent presentation. I
Thank you.
think that was very, very helpful. Are there any further questions? Ms. Moses?
Thank you so much for your presentation. I'm just wondering, throughout the course of your research, if you came across any statutes or regulations in other states, particularly focused on environmental justice issues. I think many of the folks on this panel are familiar with the burden that it is taken upon them and their community, and I'm concerned that in lower income minority communities, there may be heightened concerns.
Again, it's been a little while since I've done this review, but yes, I believe I have seen issues related to that, yes. I'd have to go back and pull my full file to find it, but that does ring.
Thanks.
Vice Chair?
And this isn't something you have to answer now, just if you could follow up with us on the standard you set of requiring the water, et cetera, all the utilities sort of already be all locked down. That sounded like a high bar, but I'm not as familiar with this stuff, so I want to make sure I'm clear. If you could let us know whether that's a common requirement in other places, I'd appreciate that.
Absolutely.
Mr. Rosselli?
Thank you, Mr. Chairman. Just one final comment and a question about the size of the EFSB. Have you seen in your research where the EFSB board actually expands or contracts depending on the size of the project? I would have hazard a guess that a transmission line going a few miles really isn't going to require 30 people or whatever on the board.
It does, I don't want to use the word common, but there does seem to be a pattern that depending on the matter before the board, that the board makeup changes to bring in the expertise you need for that matter.
Great, thank you. Thank you, Mr. Chairman.
Thank you both so much. I really appreciate your time and coming down and giving us your thoughts from the perspective of the town and the legislation we introduced last year. I think that was very helpful to the committee.
You're welcome.
Thank you very much.
Thanks for having us.
Thank you.